Hey everybody, Harry here to talk about the latest filing, a pretty important one in the New York DA, Alvin Bragg's criminal lawsuit and indictment, first in our nation's history against a former president of Trump for roughly, you'll recall, the whole hush money scheme paid out to Stormy Daniels in the way in which that was falsified or deceptively characterized. Okay, we've been waiting for a year to know what was Bragg's theory going to be. Remember, Bragg comes into office first, declines to do the case, and we knew of the payoffs and we knew they were false. But without completely going into all the legal arcana, remember that they needed to have a second crime, that the falsification, the misidentification of the business records in New York, which were where he claimed them as business expenses, is a straightforward violation, but it's a misdemeanor, and to make it a felony, it needs to be to further another crime. What was that other crime going to be? Well, when Bragg brought his indictment, he basically said, I'm not going to tell you. I don't have to choose now. It could be any of several. Maybe it's in furtherance of an election law violation under New York or federal law. Maybe it's in violation of a tax law and a tax scheme. And you may recall each of them had some possible problems. There was also a wire fraud. And when the the indictment actually came down, it was agnostic. It was basically, we'll tell you later. So Trump predictably responded with what is called a bill of particulars. He said, tell me more about exactly what you're charging me with so I can prepare my defense. That's a constitutional requirement. And today, the DA answered and basically said, nah, I don't have to, because the requirement for a bill of particulars is that a defendant, having received it or has a right to get it, if he or she isn't able to prepare a solid defense without knowing more details, it's to be able to meet the charges against them. And the DA was perfectly non-committal or agnostic on it all. He said, look, we've got this 34 count complaint and 15 pages. It gives them enough detail, and the charges could be under the tax code, could be under state election law, could be under federal election law. He knows enough to prepare his defense. And we can try to prove all of the above and argue them all to the jury. We don't have to choose now. Either way, it would still be the basic crime of the misidentification of the business records. And we're not required to actually, nail down precisely what the auxiliary crime is that ups the ante on Trump. So we'll see what the judge does with that. And it might be a good issue on appeal for Trump as well. If the continued sort of indecision and playing it loose by the DA is adequate under the Constitution, and that would mean it's adequate for Trump to be able to prepare a defense. Seems to me it probably is, right? He just has to be able to focus on the different theories. That doesn't mean he can't prepare a defense. But the bottom line here is he said, I don't know what you're saying exactly. What's your precise theory? Here's my bill of particulars. And the DA comes back and said, and you know what? You don't have to. Here are the different things it could be. But in terms of the statement of facts and what you did, it's all laid out in our 15-page, 34-count complaint. So there you have it. It will now go to the judge, who may rule that Bragg has to give more, or he may say, no, that's enough. I've talked to you before about New York law saying that the prosecution doesn't have to choose in advance. So that would suggest that it's okay. But it would also, I think, produce a distinct issue on appeal. So there you have it. Let's see what the judge does with the bill of particulars and the basic non-response, no, I don't have to, response by the DA. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.